Is a conviction for burglary in the third degree sufficient when a person steals 2 Red Bulls and makes furtive movements? To find out, you have to read People versus Williams, but it's 18 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases and I try to do it in 5 minutes or less. This is the episode on the case of People versus Williams. The citation for this case is 2025 New York Slip Opinion 00901, published by the New York Court of Appeals on February 18th of 2025. The issue in this case, it's sufficiency of evidence for the crime of burglary in the third degree. The background that's helpful to understand this case is that a verdict is considered sufficient if, viewing the facts that are established in the light most favorable to the people, the prosecution, there is a valid line of reasoning and permissible inferences in which a rational jury could have found that the elements of the crime had been proven beyond a reasonable doubt. So you have to analyze all the facts presented at the trial and see if all the elements that are required for the crime under analysis, have been established. So in this particular case, the other thing you have to know is that burglary in the third degree, which is Penal Law 140.20, it's a D nonviolent felony, that crime is defined as knowingly entering or remaining unlawfully in a building with the intent to commit a crime therein. And intent, a person acts intentionally with respect to conduct described by a statute defining an offense when his conscious objective is to cause such result or to engage in such conduct, and a person enters or remains unlawfully in a building or upon premises when they're not licensed or privileged to do so. Those are the elements of Burg 3. What are the facts of this case? The facts are that on January 19th of 2017, Raymond Williams allegedly entered the CVS store at 300 Park Avenue South in Manhattan, New York County. Several store cameras captured him walking outside the store, looking over his shoulder, then turning around, going inside the store. He was carrying a bag. He went down an aisle. He looked over his shoulder one time. He turned around, proceeded down the aisle to where the beverage coolers were. He opened one of the coolers, reached in, removed 2 cans of Red Bull. Holding one in each hand, he walked down the aisle toward the front of the store where the checkout was. He did not exit the store with them, but instead walked past the exit toward the self-checkout area. He never put or attempted to put down the cans into his bag or pockets, but a CVS employee recognized him as a perpetual or repeat shoplifter, allegedly from their list of people who were trespassed from the store, which barred him from entering into any other CVS store, and directed the head cashier to alert the store manager. They buzzed security. The store manager asked him to leave. She said, "Stop. Give me the items. You don't belong here." Mr. Williams then allegedly handed over the cans and left. The store manager said that he slammed down the cans on the counter, and those cans were then returned to the cooler. So the defendant ultimately, these are the facts that were established at the trial. Additionally, about a few weeks later, or at some subsequent time, there was an interview of the defendant where he gave a statement to detectives where he admitted stealing cans of Red Bull, but it's not clear whether it was that day or a different day. In fact, the whole incident was captured on video, and the things that he mentioned in the admission statement to the detectives didn't really line up with what he said happened on the video. So that's why it's not clear whether he was describing this stealing of Red Bulls or a different stealing of Red Bulls incident. The jury then found the defendant, Mr. Williams, guilty of third-degree burglary, and the court sentenced him as a second violent felony offender to the maximum term of 3.5 to 7 years incarceration. It's actually a second felony offender. The defendant appealed that it was insufficient evidence to justify the conviction. The appellate division affirmed the conviction, said it was sufficient, goes to the Court of Appeals. And here we have 2 different decisions. The majority says it is sufficient. Why? The majority says, viewing the evidence in the light most favorable to the people, the elements are established. How? They say with respect to the intent to commit the crime therein. Oh, with respect to the knowledge element, with respect to him knowing that he's not licensed or privileged to be in the store, it's established by the trespass notice that the defendant signed, barring him from going to CVS's, as well as a testimony from the CVS employee who told him he was not allowed to go into CVS in the previous incident. As to the intent element, the jury could have found that the defendant entered the store with the intent to commit a crime by the surveillance footage showing the defendant engaging in furtive behavior, which they could have viewed as furtive, the looking over his shoulder several times outside and inside, and the store manager telling when they say stop, the defendant never offered to pay, and he slammed the Red Bulls on the counter. Those are things the jury could have used to deduce and infer that he was guilty, that he had the intent to commit a crime inside. And also they could have considered and concluded that the statement he gave was about this particular theft of Red Bulls when he talked about having the intent to steal Red Bulls. There is a strongly worded dissent by Judge Wilson in the minority, in the dissent here. This is not the majority decision, it's the minority decision, that says that, first of all, that the elements are not established by the facts here, that all those things I just mentioned are not indicative, they're not probative of the elements that are addressed. But more importantly, he says, it's inherently unfair to make a person who's alleged to have tried to steal two cans of Red Bull that were $6 to, as a result, put him in jail for up to 7 years at a cost of up to $4 million. That the whole criminal justice system is sort of built the wrong way, where petty crimes like this can result in massive expenditures of taxpayer funds and massive expenditures of time on the life of the person who's convicted. But once again, the majority here, the majority decision is that it is sufficient, and the appellate division is affirmed, the lower court is affirmed. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.